Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. Let's see if this is working correctly. It looks like it is. So make yourselves comfortable, folks. I am, of course, attorney Andrew Branca for the Law of Self-Defense. Thank you. Thank you very, very much. Let me make sure that everything is working the way it ought to be working, and it is. All right. Except, of course, for locals. So for those of you who may not know, Law of Self-Defense does have a locals account. I rarely use it, but I decided to try to use it today as part of our live stream. And it turns out locals does not allow every account to live stream. So I've sent them an email for access to the necessary settings. Maybe that'll happen in the future. But meanwhile, we are streaming, I certainly hope, on Rumble. And we are. Great. And on the Law of Self-Defense dashboard. Welcome, everybody. Welcome, welcome, welcome. All right. So we're here to talk about a blog post that was published this morning by Professor Jonathan Turley that I think was not very good. Now, having said that, of course, I don't know Professor Turley personally. I've never met him. I'm sure he doesn't know I exist. He is an extremely prestigious, credentialed, prominent law professor and attorney. I'm not going to read his bio, and I'll show you why I'm not going to read it, because this is what it looks like. This is from his blog. Jonathan Turley, biographical information. He's currently, I believe, a professor at George Washington Law School. But I'm just going to scroll through. This is Professor Turley's bio. This is a heck of an academic and legal career. It just goes on and on and on. And I've read a lot of Professor Turley's blog posts and seen him comment on Fox News and all that. And he generally seems to me as being top shelf when it comes to legal analysis, legal explanation. So I have to say, I was genuinely a bit disappointed when this morning's blog post was brought to my attention. Now, in fairness, of course, my disappointment has to do with matters of use of force law, where I have a great deal of particular focused legal expertise. Most lawyers do not have. Certainly, Professor Turley has similar or greater expertise in a wide variety of legal topics about which I know nothing. So I want to make clear, none of this is intended to disparage Professor Turley personally or professionally. He's a genius, no question about it. But when I saw this use of force blog post this morning, it struck me as, well, it was described to me by the person who brought it to my attention as being an unusually muddy piece of work from Professor Turley. And I think muddy is probably the best way to describe it. If I had posed this case as a law school final exam question in a mythical use of force law seminar, it wouldn't get a good grade because it reflects a fundamental failure to precisely understand the legal doctrines that are being understood, to conflate different legal doctrines together, which is the most common thing in the world. I mean, judges do it, lawyers do it all the time. But that doesn't make it a good piece of work. And it doesn't mean that when judges and lawyers are doing it, that it's good. And it doesn't mean when Professor Turley is doing it, it's good. More clarity, I think, would serve the interests of the reading public, which is, of course, largely what we do at Law of Self-Defense, is to provide clarity on the matter of use of force law. So with that disclaimer out of the way, and I don't know if Professor Turley will end up watching this or not. Sometimes that happens. I critique a law professor's work, and the next thing you know, we're having lunch someplace and having a great time. You Law of Self-Defense members have seen that happen before. If he's watching, Professor, nothing personal, nothing professional, just I think greater clarity is needed on these topics. And you're sufficiently high profile that I felt obliged to bring that clarity here for the Law of Self-Defense community and people generally. So with that out of the way, let's go ahead with the formal start of today's show. All right. And before we dive into the proper show, I do want to mention for everyone's attention that if you like this law of self-defense content, and I don't know why you'd be here if you didn't, and would like to learn it at a deep and precise level, we have a full day law of self-defense advanced class taking place in a couple of weeks, 2 weeks from this Saturday. The class is on October 7th, Saturday, October 7th. It's our 7-8 hour law of self-defense course. We only teach it twice a year, folks. This is the second time for 2023. So if you missed this one, you're not going to be able to access it for another 6 months or so. And I'm just going to scroll through the website here to sign up. And you'll see we detail more than 100 very specific use of force law questions. Those are the red bullet points here that we answer over the course of the show. And then we have effectively unlimited Q&A throughout the show and at the end of the show. Sometimes the Q&A is so long that we do have to break away because I've already been talking for 7 or 8 hours and covered the Q&A over subsequent days. But we answer every question that we can, folks. All these red bullet points are the specific questions we answer. And you can access this webpage, learn more about this course, by going to the little URL there at the bottom of the screen, lawofselfdefense.com/advanced. When do you need to know this stuff, folks? 2 weeks from today or 6 months from today? Do you know when you might be compelled to defend yourself against criminal predation, defend your family, defend your property? That's not up to you, right? That's up to the bad guy. The bad guy chooses the time, place, and manner of attack. I would suggest you need to learn this stuff now, so you can effectively and decisively defend your family with the confidence that you're well inside the actual legal boundaries and have minimized your risk of losing the legal fight to as close to zero as possible. And the cost of losing the legal fight, folks, is very likely the rest of your life in a cage. We don't want that for you. I'm sure you don't want that for you. Your family doesn't want that for you. So as we say here at Law of Self-Defense, you carry a gun, or whatever you do for self-defense so that you're hard to kill, you also owe it to yourself and your family to make sure you know the law so you're hard to convict. And this full day class on Saturday, October 7th, our Law of Self-Defense Advanced class, is the single best way to do that in the most time-efficient way possible. And by the way, if you have a conflict on the date, I would still urge you to register, because we do make the playback of the class available to all the registered students for a couple weeks, at least a couple weeks afterwards. So even if you were present on Saturday, you could watch portions again if you like, want to refresh your recollection. It is a fire hose of information. And if you can't make it for the live stream on Saturday, you can still access the playback over the course of the next couple of weeks afterwards. So again, that's Law of Self-Defense Advanced class at lawofselfdefense.com/advanced. All right. Now we can jump into things. So, whoops, that's not what I wanted to do. First, I have a news report here before we get to Professor Turley's blog post of this morning. It's from a couple days ago, but it covers the same kind of facts that we need to know about this case. So let's jump into that. It's from a local Florida news source. Here we go. Family, Central Florida dad killed in front of 8-year-old son amid tree trimming dispute with a neighbor. Awful. Just awful. There's the suspect on the left, the killer, Edward Druzolowski, and there's the victim, Brian Ford. So 78-year-old the Leon Springs man is in jail without bond, accused of shooting and killing his neighbor during a dispute over trees. Edward Druzolowski is charged with second-degree murder in the death of 42-year-old Brian Ford. I don't know if Steve Gosney's in the chat. He's our local Florida criminal law expert. In some states, second-degree murder is effectively the highest degree of murder without going to a capital crime, without putting capital punishment on the table. And capital punishment greatly complicates a prosecutor's efforts at trial and leading up to trial. So often prosecutors will decline to pursue a capital murder case simply because it increases the complexity of the case for them. I'm not sure if that's why we're looking at second degree here as opposed to something else. Nevertheless, 911 calls were released Monday reveal it was the suspect's wife who called for help. So the shooter's wife. The sheriff's office also released body cam video showing his arrest. Quote, my husband had it in his hand. He meant to scare him, meaning the gun that was used, presumably a revolver, as we'll see. He meant to scare him and he hit him. He was on our property, meaning the victim, or maybe meaning the husband. They were both on the shooter's property. The victim's mother tells a harrowing story. Her son was trimming tree limbs for her when he was shot and killed in front of his 8-year-old son. Oh, so the tree trimmer was at his mom's house, basically neighbor to the shooter. She says she and her neighbor weren't exactly friendly, but never expected something like this. The son said, he shot my dad. He was screaming, he shot my dad, and he wanted to go over and lay on top of his dad's body. Linda Ford, the mother of the victim, said. Then some emotional stuff here. I heard a big boom, and then he started, the son, he shot my dad, he shot my dad. Okay. Druzolowski let his court-appointed public defender plead his case for bond, telling the judge that he had no prior criminal history, but Assistant State Attorney Dustin Haven argued against it. He admitted and was unarmed and had made no threats. That's actually contested, as we'll see. There is testimony from the victim's own son, the 8-year-old, that his father had threatened the shooter with death immediately prior to the shooting taking place. According to the sheriff's office, the suspect saw the victim doing the tree work and ordered him off what he claimed was his property. Though the victim's mother told the TV media that her son was still on her property. My fence is 2 feet inside my yard, so I go another 2 feet outside my fenced area. Who knows, right? Somebody will have to make a factual determination. In my experience, it's not that common for people to put their fence up 2 feet inside their property line. But when the victim didn't leave, the tree trimmer, investigators say the suspect shot him. The victim's mother says the suspect was still holding the gun when she got there and pointed it at her and her grandson. He kept pointing the gun at him. He said, shut up, kid, to him. And then Ed was pointing the gun at me. He was walking towards the fence line, and I backed up, and I was screaming through the yard. And that's the whole news story. All right. Let's turn now to Professor Turley's write-up here. And there's Professor Turley on the right, good-looking gentleman, and Edward Druzolowski on the left, a less good-looking gentleman. So Edward Druzolowski, 78, is facing a second-degree murder charge in Florida after gunning down his neighbor over a tree-cutting dispute. Brian Ford, 42, the victim here, was on Druzolowski's property. So Professor Turley is saying, contrary to what we just saw in the news report, that the claims by the victim's mother, that in fact the victim here was on Druzolowski's property. So we'll go with that presumption moving forward, just because it's the context in which Professor Turley wrote this blog post. Brian Ford was on Druzolowski's property, trimming limbs from a tree between their property when Druzolowski told him to leave. What unfolded led not only to murder charges, but may lead to a controversial defense. That's really what we're here to talk about. So according to the sheriff's office, Druzolowski said that he was watching a football on Sunday night when his wife told him that Ford was on their property cutting branches. He said he was afraid of Ford because Ford would talk about his doing time in prison and fighting other inmates. Okay, would that be evidence relevant for admission at trial? Sure. I mean, presumably, Druzolowski is going to be claiming self-defense as his legal defense, his justification for the shooting death of Ford here. And, of course, if you're claiming self-defense, you have the up to 5 elements of self-defense, one of which is reasonableness. Your fear of imminent harm has to be a reasonable fear. That's a subjective and objective state of mind. But for the subjective component, your knowledge of that other person's reputation, history of violence, that you knew at the time you acted in self-defense is absolutely relevant evidence that would be admissible at trial. Now, if you learned of that character for violence after you acted in self-defense, it might well likely not be relevant for admission because it did not inform your subjective state of mind in acting in self-defense at the time. Druzolowski told the police that he brought the gun for protection, even though they had never had problems in the past. Well, Okay, you're going to have a problem now, right? You're going to a confrontation. You know you are. Someone's on your property, which is unlawful. They're not there by license. It's trespass. And you have knowledge that that person has a character for violence. So being armed doesn't strike me as unusual. Now, frankly, I would be armed anyway because I'm always armed. I wouldn't be grabbing a gun just to go out and confront this person. I'd already have a gun on my person because that's my normal state of being. Druzolowski said that he told Ford to get off his property and that Ford cursed him and told him to mind his own business. What are we not seeing here? Any testimony that Ford claimed that he was actually on his mother's property and not on Druzolowski's property. Druzolowski then pulled his gun and pointed it at Ford. He said that Ford was undeterred and said, "You are pointing a gun at me. Are you going to shoot me?" All right, so here we have already an interesting question before we even get to Professor Turley's analysis. This pointing of the gun. Let's assume we have a simple trespass taking place. So someone's present without license, but not with malice, not to commit some further criminal mischief. They're simply present without license. So a simple trespasser, can you use force to remove a simple trespasser from your property? Yes, you can. You can only use non-deadly force to do that. So you can't simply shoot a trespasser. That's true everywhere in the United States. You could grab them by the arm if they are non-compliant with your orders to get off the property and use non-deadly force to remove them from the property, but not deadly force. Did Druzolowski use deadly force to attempt to remove Ford as a trespasser? Well, of course, we know eventually a shot was fired, but that's purportedly in response to some further threat by Ford. In the context of simply attempting to remove a trespasser, is the pointing of the gun at the trespasser the use of deadly force? Well, courts vary on this question. Most courts in most jurisdictions will hold that use of the firearm means discharge of the firearm. That merely pointing of the firearm is not a use of deadly force. It's a threat of deadly force, but it's not a use of deadly force. So we'd have to see how Florida treats this kind of dynamic. Now, can you threaten deadly force against a simple trespasser, even if you don't intend to actually use it? And imagine you never do use it. All you ever do is a threat. Is that aggravated assault with a deadly weapon? You've put them in subjective fear of imminent deadly force harm, presumably, right? By displaying the gun. Well, we actually have a recent Florida case on this. By the way, this article is hyperlinked in the description of today's show for Law of Self-Defense members. Also linked is this court decision we're going to look at right now, as well as a Law of Self-Defense show I did on this court decision shortly after it came out. But the court decision is this: Burns v. State, Florida Court of Appeals, 2023. This was from May of this year, and I believe the show I did it was from a week or so after this decision was handed down. And this involved, guess what? Tree trimming. Again, just like this Druzolowski case. So a homeowner, Richard Burns, the defendant at trial and the appellant on appeal, got into a confrontation with some men who were a 5-man tree cutting crew that occurred in the yard of his home. The way the confrontation began here isn't really important. One of the crew members made sexually suggestive gestures towards Burns' fiance. Another waved a running chainsaw towards his dogs. And Burn demanded they leave. When they refused to leave, he retrieved a handgun from his residence and openly carried it in his yard while loading it by advancing a bullet into the chamber. So he walks out of his house with a gun and cycles the slide in view of these tree trimmers. And he was charged with aggravated assault, presumably with a deadly weapon. And he tried to get the charge dismissed, arguing that, no, he's just allowed to do that when he's on his property. And the trial court said, no, I don't buy it. You're not just allowed to do that. You put those people in subjective fear of imminent deadly force harm, and it's up to a jury to decide whether you had justification to do that. But the criminal charge is going to be put in front of the jury for their consideration. So the aggravated assault charge was permitted before the jury, and they convicted him on that charge. Well, on this appeal, the appellate court said, nope, as a matter of law, here we go. The mere display of a gun is not deadly force as a matter of law. So mere display is not enough. Even the display of a deadly weapon without more is not deadly force. And this Court of Appeals ruled that as a matter of law, walking out gun in hand, cycling the slide in view of the victims cannot be aggravated assault with a deadly weapon because you're simply permitted to do that on your property. Now, would this extend to Druzolowski pointing the gun at these tree trimmers? I think it's a pretty parallel case. I don't think there's much difference, to tell you the truth, between cycling the slide in someone's view and pointing the muzzle of the gun at them. A little bit, maybe, but I think they're certainly within the same ballpark. All right, let's get back to the Turley article. Let's see. Druzolowski then pulled his gun, pointed it at Ford. He said that Ford was undeterred, said, "You are pointing a gun at me. Are you going to shoot me?" Druzolowski said Ford was approaching him as he told him to stop. So you have your gun out, you're pointing it at someone, and they're advancing on you. What's a reasonable inference from that set of facts? They're clearly not afraid of your gun, right? They're going to close proximity, and once they're within arm's reach of that gun, it becomes their gun. Unless, of course, you're prepared to discharge the weapon at them. But if you're not prepared to shoot them, if shooting is off the table legally or because of your own decision-making, that becomes their gun. To my mind, it's no different than if that person is reaching for a gun on a table while you hold them at gunpoint. In fact, it's worse because they apparently believe they have nothing to fear from you holding that gun. So they can just take it from you because they don't believe you're going to shoot them, or they would not be doing this. They would not be advancing on you. And if they get the gun, it's worse than them reaching for a gun on a table because they're simultaneously disarming you while they're disarming yourself. If they're reaching for a gun on a table, they're arming themselves, but you still have your gun. It's quite different if they take yours. Now we get to some craziness by the defense, for sure, by the defender, the purported defender. Druzolowski said he kept the first two chambers empty for safety. So Professor Turley doesn't say, the news article didn't say, but obviously multiple chambers means that this is a revolver for all practical purposes. Semi-automatic pistols, handguns, semi-automatic handguns, they only have one chamber. And rounds are inserted in the chamber, fired, ejected from the chamber, but there's only ever the one chamber. Revolvers have a cylinder with multiple chambers in it, often 5, most commonly 6. It could be more depending on the gun, but there's a whole bunch of different chambers into which there's a cartridge. Normally, a cartridge would be loaded. Some exceptions for single action pistols where it was historically common to leave the chamber under the hammer while you were carrying it unloaded because of the risk that the hammer could bump on something and discharge that round when you were not meaning to discharge the gun. But typically, modern day revolvers, you just load every chamber in the cylinder of the revolver. Druzolowski said he kept the first two chambers empty for safety. Why would you keep the first two empty? Again, if this was a single action revolver, I could understand keeping the one chamber sitting under the hammer empty, but two? Why two? He said that he pulled the trigger on the first empty chamber. Okay. This, I guess, was supposed to be a warning trigger press, a warning hammer drop. By the way, folks, if the chamber under the hammer in a single action revolver is the empty one, to fire the gun, even with a double action revolver, to fire the gun, the hammer has to cock. That rotates the cylinder to the next chamber. So the empty chamber under the hammer becomes irrelevant at that point. He said he pulled the trigger on the first empty chamber, but Ford continued to advance. He then pulled the trigger again, and it went off. And Druzolowski here is saying, well, I was surprised it went off because I keep the first two chambers empty. That was his plan. Keep the first two chambers empty so you could have two warning hammer drops. Why is that a bad idea, folks? Well, first of all, you may not have time. You may not have the luxury of two harmless hammer drops if you're actually facing an imminent deadly force threat, right? What if Ford had pulled out his own gun and now it's a gunfight and you have to fire twice before a round comes out of your gun? So you may not have that luxury. Second, and probably what happened here, is it's too easy to screw up. It's too easy to make a mistake. Maybe there were two empty chambers in this revolver. Maybe one of them was under the hammer. And then when the hammer was cocked for the first shot, that empty chamber goes away. The second empty chamber is now under the hammer when it falls. But then when you go to shoot again, the second empty chamber becomes irrelevant, and a chamber with a cartridge under it in it falls under the hammer. And you hear a bang when you were expecting a click. That may well be what happened here. So what Druzolowski is saying is he didn't actually intend to use deadly force. He thought this was going to be a click, not a bang. Is that a problem for the defender here? And I mean, Professor Turley doesn't speak to any of this. So we're not even at the portions of the blog post yet where I have disagreement's probably a strong word, but where I sense a lack of clarity in the legal explanations here. But yeah, this could be a huge problem for Druzolowski, because self-defense is inherently an intentional act. If you're using deadly force against another person and want to justify that as deadly force, you're shooting them with a bullet, and you want to justify that as self-defense, the shooting with the bullet has to be an intentional act, not an unintentional act. There's no unintentional self-defense. That's not a thing. The whole argument of self-defense is that you reasonably perceived an imminent threat of unlawful deadly force harm to yourself or another person, and you intentionally used deadly force to stop that unlawful deadly threat. If your use of force was not intentional, it was not self-defense. It was something else. What else could it be? Well, in theory, it could be accident, but accident, so there is a legal defense of accident, just like there's a legal defense of self-defense. If your conduct results in some harm that was entirely unpredictable, unforeseeable by you, that can legally simply be an accident, and an accident carries no legal liability. It's unforeseeable. So the illustration I commonly use is you have an elderly aunt and you go to her apartment and she asks you if you can move a dresser from one side of the room to the other, and you're happy to do that for your aunt. So you pick up this heavy dresser, you move it across the room, you put it on the floor, and unbeknownst to you, the floorboards, the beams under the floor are rotten, eaten by termites, and the dresser falls through the floor and kills another old lady in the apartment below. Did you kill that old lady? Your conduct did, for sure, right? She would not have died but for your moving the dresser, but you have legal liability for that. No, that's a genuine accident, completely unforeseeable by you. There was no way you could know that the dresser would fall through the floor. When you're trying to claim accident in the context of a firearm, the handling of a firearm, it just doesn't really work, because firearms are inherently dangerous instruments. We all know they're deadly if mishandled. Everybody does. So it's simply presumed that you're aware that mishandling of it will create an unjustified risk of death or serious bodily injury to others. So there's no real accident with firearms. I would argue there's no real negligence in the handling of firearms. That if you kill someone while handling a firearm, really the only way to do that is to violate the fundamental rules of gun safety. That becomes a reckless killing. And negligent killing would be cause for civil liability. The other party could sue you, or their survivors could sue you in civil court for a judgment for the loss of their loved one. Recklessness gets you into criminal court. That's a criminal state of mind. This is what happened with the Alec Baldwin shooting of Helena Hutchins. He was handling a gun, didn't follow the rules of gun safety, knew he was handling a real gun capable of killing people, never checked to make sure it was not loaded, pointed it at Helena Hutchins and killed her with it. That's reckless manslaughter every day of the week and twice on Sundays. Now, he managed to get his charges at least apparently dropped. They're dropped without prejudice. So they could, in theory, be brought back. But that was a political decision by the prosecutor, not a legal decision. The prosecutor in New Mexico has everything they need to prosecute and convict Alec Baldwin of reckless manslaughter if they wanted to do that. It's up to them, totally within their discretion. So this could well be reckless manslaughter here. He decided he was going to follow this 2 empty chambers plan, and he screwed it up, and he killed someone unintentionally. But if you're pointing a gun at another person, and especially if you're pulling the trigger and you know there's some bullets in the gun and you just mess up your 2-chamber policy, were you creating an unjustified risk of death or serious bodily injury to that other person? Knowingly. Yeah, you were. And if this is a reckless killing, reckless manslaughter, and I'd have to look to see he's charged with second-degree murder, which is an intentional killing. But if this is a reckless killing, that could well be a lesser included offense, a second degree. I'd have to check. It's been a while since I looked that closely at Florida killing laws. You can raise the legal defense of self-defense to a second-degree murder charge, but not to reckless manslaughter, not to an unintentional killing. Let me clarify that. I don't want to be unclear either. I accuse Professor Turley of being unclear. Now I feel like I might have muddied things up. You can raise self-defense as a legal defense to a charge of reckless manslaughter, but it works in a different way. So when you are charged with an intentional killing, you're not denying it was an intentional killing. You're saying, if you're claiming self-defense as a legal defense to an intentional killing, you're saying, yeah, you're not saying it wasn't me or it was an accident. It was unintentional. You're not saying any of that. You're saying, yeah, I shot that guy on purpose. I killed him, as a result of the gunshot that I fired on purpose. But I did it with the legal justification of self-defense. So you're conceding the elements of the criminal charge. You're not denying them. But you're saying you should be nevertheless excused from legal liability because you have the legal justification of self-defense. The self-defense becomes like an imputed negative element of the criminal charge. So even though you committed every element of the criminal charge, which would normally be enough for a conviction, you nevertheless are free of legal liability because of the justification of self-defense. When you're claiming self-defense to a charge of reckless manslaughter, it works differently. You're not conceding the elements of the criminal charge. One of those elements is recklessness, the knowing creation of an unjustified risk of death to another person and ignoring that risk. You're not conceding recklessness. What you're doing is you're saying it was not reckless because it was lawful self-defense. And this is a subtlety, it may be hard to grasp, but it's referred to as an element eliminating or negating traverse defense under the law. So self-defense to second-degree murder, you're saying, yep, I did everything. Every element of the criminal charge did it. But I'm still free of criminal liability because my conduct falls within the definition of the justification of self-defense. Reckless manslaughter, you're saying, no, I don't concede the elements of reckless manslaughter because it was not reckless, because it was lawful self-defense. And lawful self-defense, one of the elements is reasonableness. If the jury believes it was lawful self-defense, then it was reasonable. And if it was reasonable, it was not reckless. Reckless is inherently unreasonable. But folks, please don't do this kind of thing. I'm going to leave a certain number of chambers empty. The first round of my shotgun is going to be rock salt, is going to be a beanbag round. So the first shot I fire will be non-lethal, and only if they get past the beanbag round or the rock salt will the shots be. People screw it up. You might screw it up. And you'll be firing what you think is a non-deadly round because the conditions for deadly defensive force have not yet been met, or you would have cycled that non-deadly round out to get to a deadly round. And you'll end up killing somebody under circumstances in which even you didn't believe that killing was legally justified. So I much prefer that. I definitely advocate that people have both deadly defensive force and non-deadly defensive force options on the table. But they should be, in my opinion, distinct tools. I had someone pitch to me the business idea of rounds for a real firearm, for a real handgun, but they'd fire like wax plugs. So the first couple of rounds in a semi-automatic pistol would fire, but it'd just be little wax plugs. They wouldn't be deadly force. Same problem is here. How do you know you're not going to screw it up? First of all, how do you know you're not going to need a bullet the first time you fire the gun? What happens if you screw it up? So I believe that deadly weapons should be left as deadly weapons. You should not be pulling stunts to make them operate in some kind of hypothetical non-deadly force manner. It's why I don't like the products in that company Byrna that produces a pistol that fires a pepper spray capsule. It looks just like a real gun. How easy to confuse with a real gun. How easy for observers, by the way. Here's another risk. So you have that shotgun with the beanbag round, or you have this guy's revolver that's supposed to have 2 empty chambers. And an observer, a third party, sees you pointing that gun under circumstances where deadly defensive force would not be warranted based on their reasonable perception of what's going on. Could they shoot you in defense of that other person you're threatening and have that be lawful? Sure. So don't conduct yourselves in ways in which these misperceptions can occur. And that happens not infrequently, folks. Often it's the police. They turn a corner. They encounter someone holding a gun under circumstances where there's been killing going on, and they shoot that person. And sometimes that person is just a bystander who just picked up the gun. So your defensive tools, in my view, should either be clearly, explicitly, and only deadly force defensive tools like a pistol, a shotgun, whatever you pick, but it's never used for non-deadly defensive purposes. And then your non-deadly defensive tools should be things that are not going to be perceived or used for deadly force purposes. Canisters of pepper spray, maybe a taser. I don't really recommend tasers, but tasers, tasers are designed so they don't feel like, well, they kind of do feel like a gun, don't they? We've seen that get confused, haven't we? Kim Potter, taser, taser, taser. And they sell those things in all black. Would you believe it? Kim Potter's was in all black, and she still confused it. All right. So please don't do this kind of 2 chambers empty thing. Ford was shot in front of his young son, the 8-year-old son. The most helpful evidence for Druzolowski, the shooter, may come from that child, Ford's 8-year-old son, the victim's 8-year-old son, who told police that his father, the victim, told Druzolowski, "I'll cut your head off with the chainsaw." Was he holding a chainsaw? Yes. Was he in sufficient proximity to bring that chainsaw to bear imminently? I'm presuming so, that he wasn't more than 20 or 30 feet away. Would a chainsaw be readily capable of inflicting death or serious bodily injury? Now, the article goes on here. Professor Turley reports that, however, he said that the chainsaw was not on or running at the time. Does that matter? Well, clearly, if the chainsaw is running and it could be brought to bear, it's going to inflict death or serious bodily injury, right? The definition of deadly force. But if it wasn't running, it's still what? What's a chainsaw weigh? 8 pounds, 10 pounds, metal object? If Ford was holding a bat and said, "I'm going to hit you in the head with this bat," the bat doesn't have a running chain. But would that still be deadly force? Just as a blunt impact weapon? The chainsaw could be used in that manner, and it does have a sharp blade on it, sharp chain on it. And they're sharp, folks. They're sharp. Even when they're not running, they're sharp. It's like, 60 or 70 or 80 little cutting blades all along the length of the chain. I don't think any of us would volunteer to be struck with a non-running chainsaw. We'd all be in reasonable fear of suffering, if not death, at least serious bodily injury, right? Especially if we were struck around the head, the neck. To my mind, it's like a large edged weapon, even if it's not running. But of course, this is the kind of argument that a prosecutor would make, right? Hey, it wasn't really a deadly weapon. It's not like it was running. If it was running, that would be different. By the way, how long does it take to start a chainsaw? Well, those of you who've worked chainsaws know that answer is extremely variable. Some chainsaws are pretty damn hard to start. Some of them never start. But a chainsaw that's just been running, and presumably that's the case here, generally not that hard to get started again. It's already warmed up. So not that quick. Pull the cord. And now you have something that can only be described as a deadly force weapon if it's used as a weapon. All right. Now, back to Turley. So we've previously discussed castle doctrine laws or make my day laws. This is where the muddying of the waters comes in for me on Professor Turley's discussion of use of force concepts. These are not the same things. Castle doctrine laws and make my day laws are two different things. Now, are these terms routinely used by the legal profession, by lawyers and judges, in a way that lacks clarity, fails to recognize the distinction, the technical distinction between these phrases, these doctrines, these concepts? Yes, happens all the time. Is Professor Turley a horrible person for doing what pretty much the entire legal profession does? Using these in a conflated way, even though they mean different things. No, of course not. This is kind of this is common that this happens. But nevertheless, the truth is they don't mean the same things. Castle doctrine is a very limited concept, much more limited than people think. It's common for people to imagine that castle doctrine means that you have a greater privilege to use a greater degree of force in defense of your home, your castle, than if you were out in the street. But that's not really what castle doctrine means. If you look at the historical context behind castle doctrine, it means one thing. And this one thing, it means in all 50 states. And if you attempt to define castle doctrine more broadly than this one thing, you end up with a different legal doctrine being called castle doctrine in different states. So if you expand the definition beyond its proper limits, you end up with castle doctrine with a castle doctrine that means one thing in one state, a different thing in another state, yet another thing in a third state. And that's not really a problem for practitioners within any single state. So within any single state, however they want to define castle doctrine, if they're all using the same definition, it doesn't really matter. But when you're in a forum like we are right now, and like Professor Turley's blog post is, where you're communicating to not just people in one state, but to people in every state, presumably. Then when you define castle doctrine too broadly, you're actually using a term of art that means a different thing in every single state. And that can only cause confusion. So the proper definition of castle doctrine, the historically sound definition of castle doctrine, it really derives from an age when there was a generalized legal duty to retreat before you could use deadly force in self-defense. Meaning, if you had a completely safe avenue of retreat, you had a legal duty to take advantage of that completely safe avenue of retreat before you could kill in self-defense. And this used to be the standard in the law, especially Old English common law. That's where this comes from. Because hundreds of years ago, firearms were not common. Certainly not commonly carried for self-defense. They were impractical for that purpose. So most weapons that were carried for practical self-defense were edged weapons, maybe blunt impact type weapons, cudgels, things like that. But they were all contact weapons. And if you can manage to create 30 feet of space between you and someone threatening you with a contact weapon, well, you're safe. Unless they try to close the distance, of course. But as long as you can create that distance, you're safe from their deadly force threat. Now, I'm setting aside projectile weapons, but people were not routinely carrying around bows and crossbows for personal protection. So in a world where if you can create 30 feet of space, you're safe and don't have to kill, it's a reasonable public policy to say, well, then if you can do that with complete safety, we'd rather not have you kill someone, especially in an age where, you lived in a kingdom and really the king owned everybody, right? You were a vassal to the king of one kind or another. Whatever your own status was, it was not the status of the king. It was something below the king. And the king didn't want his subjects just killing each other. That they were his. But all right, so that's the world, right? Edged weapons, impact weapons are the common weapons being used. If you can safely retreat, you're expected to do so. So there's a generalized legal duty to retreat before you can kill in self-defense. But there was always an exception to that rule. And the exception was the Castle Doctrine. And what the Castle Doctrine did was one thing. It relieved you of that otherwise existing generalized legal duty to retreat if you were defending yourself in your home. Out on the street, out in public, you had that legal duty to retreat. Everybody had it, if you could retreat with complete safety. But in your home, screw that. You don't have to back up if you're defending yourself in your home. That's the only definition of Castle Doctrine that's identical in all 50 states. So when we're talking in a context beyond any single state, I think it muddies the waters, the legal discussion, to use Castle Doctrine in an overly broad, imprecise way, because you're using a term that means different things to different people. All right, so Castle Doctrine, all it does is relieve you of an otherwise existing generalized legal duty to retreat if you're in your castle. And castle can be narrowly or broadly defined. Narrowly defined, it's inside the four walls of your house. That's how Massachusetts defines Castle Doctrine to this day, actually. Most jurisdictions in the U.S., it includes inside the four walls of your house and the curtilage of your home, the area immediately around your home that's part of the normal day-to-day function of your home. Unfortunately, curtilage is essentially subjectively defined in every case. Some states will include some specific things. I think North Carolina, for example, explicitly includes your front porch and your back porch. But beyond that, you never really know if you're standing in your curtilage or not, because it's going to be defined by a judge, or it's going to be hopefully by a judge, or defined by a jury, whether they believe you were within your curtilage. So at the time you're acting in self-defense, you often have no idea if later it will be determined that you were in your curtilage or not. And it can make a big deal, because if you were in your curtilage, you benefit from the Castle Doctrine and you don't have a legal duty to retreat. But if they decide, other people afterwards decide you were not in curtilage, then you did have a legal duty to retreat, and you lose self-defense if you violated that legal duty, and you have no justification for that killing, and you spend the rest of your life in a cage. So relying on curtilage is hazardous at best. So that's the Castle Doctrine. Make my day is something completely different. And I would argue that there are not make my day laws. There's really only one make my day law. And again, this is a phrase that's commonly used over broadly by judges, lawyers, and especially the idiots in the media doing news reporting who don't understand any of this at any level. But if you type in make my day into Google, for example, you'll see something interesting. You'll see that, and here's the Google search I did, that almost every reference to make my day is in the context of Colorado. And in my extensive research and career in use of force law, the only proper application of the term make my day I've ever seen is in reference to Colorado. It was a derogatory label put on a statute, a home defense, a defense of highly defensible statute that Colorado passed, I think in 1985, if I recall correctly. They called it, and they decided to call it the Make My Day Law. At the time, Clint Eastwood, Dirty Harry movies were on the screens, popular, and there was one of those movies where Dirty Harry used as a catchphrase while pointing a gun at bad guys, "Go ahead, make my day. Give me an excuse to shoot you." It really has nothing to do with this Colorado statute. In fact, I should pull up the statute, shouldn't I? So I can show it. Because the statute does something very specific. Very specific. It literally changes the definition of self-defense in the context of defending your home from an intruder who appears likely to commit another crime in the home in addition to the intrusion. I'm just going to pull this one up on the Law of Self-Defense website. Statute, if I recall correctly, 704.5. Yes. Here it is. Whoops. That's not the right one. Hold on a second. I have it here. All right. So what does this statute do? So one thing I'm going to point out is that this is a very unusual statute. To my knowledge, Colorado is the only state in the country that has a statute that does this particular thing. One of the elements of self-defense is the element of proportionality, that you are not privileged to use deadly force in self-defense unless you're facing a deadly force threat. There are a few other kind of edge cases where you're also allowed to use deadly force. But for our purposes discussion here, you can only use deadly defensive force if you're facing a deadly force threat. Now, there are many states that in the context of defending your home from an intruder will create a legal presumption that the intruder is reasonably perceived by you as a deadly force threat. So they're creating a legal presumption that that element of proportionality is satisfied. They are presumed, the intruder is presumed to be presenting a deadly force threat, which is what you need to be justified in using deadly defensive force. That presumption, however, is rebuttable. It could, in theory, be overcome by a prosecutor. Colorado went a step further, and they didn't merely presume that the other party was presenting a deadly force threat, that the intruder was presenting a deadly force threat. Colorado decided it's not required that the intruder be presenting a deadly force threat. If that intruder presents any degree of threat, however slight, you're privileged to use deadly defensive force against them. So it effectively does away with the element of proportionality. It doesn't merely presume the element's been satisfied, keep it, but presume it's been satisfied. It does away with proportionality entirely if you meet the conditions of the statute. And let's take a look at what those conditions are right here. Any occupant of a dwelling, meaning it doesn't necessarily have to be your dwelling. You could be visiting someone else's home, right? You're an occupant of that dwelling. You're not a resident, but you're an occupant while you're in the home, is justified in using any degree of physical force, including deadly physical force, against another when that other has made an unlawful entry into the dwelling. That's one condition. When the occupant has a reasonable belief that the other person has committed a crime in the dwelling in addition to the uninvited entry, that's a second condition, or is committing or intends to commit, now you're mind reading, a crime against a person or property in addition to the unlawful entry, so an alternative condition. And when the occupant reasonably believes that the other person might use any physical force, no matter how slight, against any occupant. That's what Make My Day does. It removes the element of proportionality as a requirement for deadly defensive force in the context of a home intrusion if these elements are met. No other state does this. Only Colorado does this. So to my mind, when the moniker was originally applied to Colorado's unique statute, and no other state has adopted a similar statute, no other state just outright eliminates proportionality as a required element in defense of a dwelling, it's inappropriate to use that moniker as a label on other states' laws that are conceptually different from what Colorado did. So another point of what I would argue is appropriate clarity there. But in any case, we can see that Make My Day and Castle Doctrine are completely different things. Castle Doctrine relieves you of an otherwise existing duty to retreat. Retreat is the element of avoidance, a distinct element from proportionality. It relieves you of the element of avoidance when you're defending in your home. Make My Day relieves you of the element of proportionality when you're defending in your home in Colorado. So two very different things, not the same legal concepts. Then he references some other cases here. We've previously discussed Castle Doctrine laws or Make My Day laws, not the same things, including other cases involving garage shootings or shooting off the property of the homeowner. If you're off the property of the homeowner, neither Castle Doctrine nor Make My Day would apply. Both Castle Doctrine and Make My Day involve you in your home defending against an intruder. If you're off your property, you're just in public. You're not in your home. You're not in your castle. Involving garage shootings, I don't want to click open every one of these cases because we'll be here all day, but Garage shootings can make a difference depending on whether or not the garage is attached to your home or detached from the home. If your garage is attached to your home, it's simply part of your home. It's part of your castle. But if it's detached from your home, it's often argued it's not part of your castle anymore. So to make it part of your castle, you'd have to argue, for example, that it was part of the curtilage. And that's a credible argument. You may be able to make that argument. I can tell you that in Colorado, the courts have found that for make my day law purposes, doing away with that requirement for proportionality, a detached garage does not qualify as a dwelling for make my day purposes. An attached garage does. So the context of the garage can make a big difference. So the garage case involves somebody in Montana. I don't know enough about this case. Let's see. A prosecutor declared that the shooting cannot be prosecuted given the state's castle doctrine or make my day law. Again, we're conflating castle doctrine or make my day. And to be clear, all castle doctrine does is relieve you of an otherwise existing duty to retreat. You still have to meet the other elements. By the way, you can get this cheat sheet, the 5 elements of self-defense, for free, folks. We give it away. Get it at lawofselfdefense.com/elements. If you don't understand these elements of use of force law, you can't possibly understand self-defense or defense of other people. You can't. These are the building blocks. They apply in all 50 states. Not all 50 states require all of the 5 elements, but these are the maximum number. Some of these elements can be waived, like under castle doctrine. If you're defending in your home, avoidance is waived. The legal duty to retreat is waived. But if avoidance is waived, the other 4 elements are still required. Innocence, imminence, proportionality, and reasonableness are still required, meaning even if someone's in your castle, before you can be justified in shooting them, you have to have a reasonable belief that they're presenting as an imminent deadly force threat to you. If any of that's not true, you can't shoot them in lawful self-defense. So castle doctrine is not a blanket license to shoot anyone you find in your home. You still have to meet those other conditions of self-defense. Let's see. So it may well have been that the prosecutor in that Montana case being referenced here decided not to prosecute because the actual required elements, but for avoidance, waived under the castle doctrine, the other required elements were robust for the defense and not subject to disproof beyond a reasonable doubt. That would be a perfectly appropriate reason not to criminally charge in that case. The common law has long offered ample protections even for reasonable mistakes. By the way, statutory law does the same thing. So you're not required to make perfect decisions in self-defense. That's what the whole notion of reasonableness is about. You're required to make reasonable decisions, but you're allowed to make mistakes. Mistakes of fact, not mistakes of law. Mistakes of law, that's on you, right? Ignorance of the law is no excuse. But you're allowed to make mistakes of fact. So someone points a gun at you and you draw your own gun and you shoot them dead because you were defending against what you reasonably perceive to be an imminent threat of deadly, unlawful harm. And it turns out their gun was a prop, a fake, a non-functional imitation of a gun. So it did not actually present a deadly force threat to you. There was no way you could have been shot by that inanimate object. You made a mistake. You perceived an inanimate object as being a real gun, and you were wrong. You were mistaken. Does that diminish your privilege of self-defense? No. No, so long as your mistake was a reasonable one. So long as your perception of that as a firearm was a reasonable perception. This is true under common law. It's true under all self-defense, statutory self-defense too. That's the legal standard. Reasonableness is enough. You're allowed to make mistakes in self-defense as long as they are reasonable mistakes. All right, so the common law has long offered ample protections even for reasonable mistakes. These laws are based on an urban legend that people are routinely prosecuted for defending their homes from intruders. I don't know why that's an urban legend. It certainly happens. It's happening here. In this case, this defendant here, Druzolowski, is going to say, I was defending my property. And he's being criminally charged. He's being prosecuted for defending his home. The laws have produced perverse results. Okay, so these laws, and I think he's trying to refer to this collective conflated phrase he's been using, castle doctrine or make my day. These castle doctrine or make my day laws are based on an urban legend that people are routinely prosecuted for defending their homes from intruders. Why should they ever be prosecuted for defending their homes from intruders? If it happens once, isn't that too much? Doesn't that make these laws? I mean, the notion that these laws were fabricated out of whole cloth without any apparent necessity perceived by the legislature, I don't know, that doesn't seem very sensible to me. The laws have produced perverse results, as in the controversial case of Tom Horn in Texas. Okay, I guess I have to look. What is the controversial case of Tom Horn? Okay, so Tom Horn shot 2 people breaking into his neighbor's house. The case has focused on make my day laws. Again, no, or the castle doctrine. Again, Professor Turley is using these as synonyms for each other. They're just not. And castle doctrine would have no application to defending a neighbor's home when you're in your own home. First of all, there's no. Why would you need to be relieved of an otherwise existing duty to retreat? Now, I think what he's doing here is he's conflating castle doctrine with things like a legal presumption that an intruder in your home is presenting as a deadly force threat. That's a different legal doctrine than castle doctrine. Let's go back to his article here. And boy, the fact that results may be perverse or controversial, that's not legal argument. That's media argument, right? Lots of cases are controversial. George Zimmerman was controversial. Kyle Rittenhouse was controversial. The legal issues in neither of those cases were complex. The black letter of use of force law was very clear in both those cases. So the media can make anything controversial. That doesn't mean what's happening is legally unsound or that the doctrines are sketchy. Let's see. Yet the popularity of these laws have spawned make my day better laws. Make my day better. I think he just means make my day laws that extend the privilege of lethal force to businesses and cars. Okay, again, this is something else. Make my day is the Colorado law that took away the requirement of proportionality if you meet the conditions of that statute for defense against an intruder in your home. Extending special privileges for the use of deadly force in defense of highly defensible property, like your home. Your home is always included as highly defensible property. Some states expand the definition of highly defensible property to your business and to your car. So the same legal presumption of a reasonable fear of deadly force harm when you're defending against an intruder in your home would apply to that intruder in your business or that intruder into your occupied car. But that's still not make my day. That's just the legal presumption of reasonable fear being expanded beyond the confines of your home. It's an expansion of the definition of highly defensible property. Florida is a castle doctrine state as well as a stand your ground state. All right, so what did we talk about with castle doctrine? Castle doctrine, if you would have had a legal duty to retreat outside your home, you're relieved of that duty inside your home. Stand your ground says you don't have a legal duty to retreat outside your home in an otherwise lawful case of self-defense if you meet the conditions of the stand your ground statute. Now, if you meet the conditions of stand your ground, and typically you're not engaged in unlawful activity and you're in a place you have a right to be, you're not trespassing, and you're not acting in a criminal manner, then you don't have a legal duty to retreat anywhere. Avoidance is waived everywhere under stand your ground in an otherwise lawful case of self-defense. But if stand your ground applies, you don't need castle doctrine, because if you wouldn't have a legal duty to retreat out in the public street, you certainly don't have that legal duty in your home, independent of castle doctrine. Stand your ground doesn't say this only applies outside of your home and you have to rely on castle doctrine inside your home. Stand your ground largely makes castle doctrine irrelevant. The only exception would be edge cases where you may not qualify for stand your ground outside your home because you are, for example, engaged in illegal activity. Say you're transporting contraband, illicit drugs. The prosecutor could argue, well, he was engaged in drug dealing. That's an unlawful activity. He doesn't qualify for stand your ground. But castle doctrine doesn't have not being engaged in unlawful activity as a requirement. The only requirement is that you're in your castle. You could be in your castle, engaged in unlawful activity, and you still get the benefit of castle doctrine. You still are relieved of that otherwise existing legal duty to retreat. Now, there are these other legal provisions, like the legal presumption of a reasonable fear of deadly force harm from an intruder. I call those defensive, highly defensible property statutes, not castle doctrine. Castle doctrine is different. Those other statutes, a legal presumption of reasonable fear from an intruder, those are often conditioned on you not being engaged in illegal activity or using the property for illegal purposes, like drug dealing. So you could lose the legal presumption that you had a reasonable fear of death. You don't lose self-defense generally. It's just you don't get the benefit of the legal presumption that the elements of self-defense have been satisfied. And you don't lose castle doctrine. So again, these are all different things. Florida is a castle doctrine state. And of course, this shooting over the tree trimming happened in Florida, to remind you. Florida is a castle doctrine state as well as a stand your ground state. That could factor heavily into the criminal investigation. Maybe, maybe not. The only way it would factor in, well, first of all, there would have had to have been a completely safe avenue of retreat in the first place. Because if there isn't a completely safe avenue of retreat, there's no legal duty. You're not required to increase your jeopardy to try to escape the threat before you can lawfully defend yourself. So the first question is, well, would completely safe retreat have been possible once the threat with the chainsaw was made? I mean, this defendant does not look like a spring chicken. What did they say? It was 78? How fast is he going to run at 78 from a 42-year-old? Wielding a chainsaw. So his reach is what? Another 2-3 feet out from the end of his hand. So I would suggest it's unlikely, unless there was really substantial distance between them, that a completely safe avenue of retreat existed at all. And in that case, there's no legal duty existing to try to retreat, and both stand your ground and castle doctrine become irrelevant, because all either one of those does is deal with that legal duty to retreat, deal with the element of avoidance. That's it. So the only way it'd be relevant to the criminal investigation is if safe retreat was even possible. And then Professor Turley notes, the stand your ground law was widely debated with the George Zimmerman murder case. And see, this is just, again, to my mind, muddying of the waters. The George Zimmerman case had nothing to do with the legal duty to retreat. Retreat was never on the table because retreat was not safely possible. At the moment George Zimmerman had to make the decision to shoot Trayvon Martin, to use deadly force in self-defense, he was pinned to the ground. He'd been struggling for minutes to try to escape. It was impossible. So safe retreat was not on the table. And if there is no safe retreat on the table, there is no legal duty to retreat. And if there is no legal duty to retreat, you don't need, stand your ground doesn't apply. You don't need a law that relieves you of a legal duty that you already don't have because it's not possible. So, and I know the media reports this. Everyone reports that the George Zimmerman case involves stand your ground. It just didn't. And I understand when the media does this kind of thing because they're idiots. I think the world of Professor Turley, and I expect more. I expect for him to understand that, in fact, whatever the controversy was, whatever idiots were debating, in fact, the George Zimmerman murder case had nothing to do with stand your ground. Not even the improper understanding of stand your ground, that's actually self-defense immunity. That also was never applied in George Zimmerman, even though it's not stand your ground. Self-defense immunity, again, is a completely distinct legal doctrine from stand your ground. But again, people conflate the two all the time, which only creates confusion. All right, continuing now. The shooting in this case occurred outside of the house. It is likely also outside of the curtilage of the home, where the protection of the domicile can extend. Well, that's a proper statement of the law. I'm not sure how Professor Turley knows that it's likely, more likely than not, that it was outside the curtilage. I've seen no photos. We don't know if where the shooting occurred would meet the character, would have the character of qualifying for curtilage. Is it an area immediately outside the home that's part of the normal day-to-day use? You need facts to make that determination. I've seen no indication of such facts. Was he 10 feet outside his front door? Was he 500 yards from the front door of his house on a part of his 40 acres, if he had 40 acres, that was not routinely part of the day-to-day function of the home? I don't know. But I don't think Professor Turley knows. And without even those facts, you can't even make a subjective assessment of whether it was likely in the curtilage. But the only reason the curtilage would matter, again, would be for purposes of castle doctrine. Whether or not there was relief from an otherwise existing legal duty to retreat. No other purpose. All these other laws, the Colorado Make My Day law, these legal presumptions of a reasonable fear, they all require an unlawful entry into the home. Not merely a simple trespass on open land. An unlawful and typically forcible entry. So something was broken to get in. That didn't happen here. It's likely also outside the curtilage of the home where the protection of the domicile can extend. However, Druzolowski is saying that Ford had the chainsaw and was threatening him. A position partially supported by his son, by Ford's son. Remember, Ford's son has told police that his father threatened to cut Druzolowski's head off with the chainsaw. And he had a chainsaw in hand. So if you believe that Ford had the means, had the ability, opportunity, and jeopardy, that's the definition of the element of imminence for legal purposes. Did he have the ability to cause Druzolowski death or serious bodily injury? I would suggest so. Even if the chainsaw was not running, if nothing else, it's a heavy, blunt object with a sharp blade on it, chain on it. Serious bodily injury is simply more than minor injury, right? Often it's some kind of scarring, loss of bodily function. I mean, you want me to hit you in the head with a chainsaw? You don't think that would cause you serious bodily injury? In the neck? With the chain? And it doesn't have to be certain to cause serious bodily injury. It has to be reasonably likely to cause serious bodily injury. So that would be ability. I certainly think the ability was there. Did he have the opportunity to bring the chainsaw to bear? Well, that's a function of distance between the two men. Could he have brought the chainsaw to bear before Druzolowski could defend himself? We don't know those facts. And jeopardy. Was he conducting himself in such a way that a reasonable person would believe he intended to bring that ability and opportunity to bear? Well, he said he was going to cut his head off. Ford said, according to Ford's own son, that he intended to cut Druzolowski's head off with that chainsaw. Assuming the distance is sufficiently proximate that the threat had a reasonable means of actually being carried out, then you have AOJ, then you have an imminent threat. And I would suggest an imminent threat of death or serious bodily injury. If you have that, and you're in a stand your ground state, and avoidance is off the table, you have lawful self-defense. So that statement by the son is pretty important. And by the way, I've read a number of news reports on this, and I've not seen that cited elsewhere. I'm not suggesting Professor Turley is misstating the fact. I think if he says it, I believe him. I think the media is not reporting it because it does so buttress Druzolowski's argument for self-defense, and they don't want that. They want the old white guy to be guilty of murder. Let's see. Continuing, there is an allowance in torts. So torts are civil suits, civil law, civil liability for mistaken self-defense. Well, that's true. Also in criminal law, it's the same. Mistaken self-defense, if the mistake was reasonable, that's still valid self-defense, relieves you of criminal liability, not just civil liability. And then for some reason, I don't understand, Professor Turley quotes a Colorado court decision in reference to this Florida case, and the Colorado decision is from 1896. Professor Turley, I wish you'd asked me. You can find a appellate court case on this probably from every state in the country within the last few years, recognizing that reasonable but mistaken self-defense is still perfectly valid self-defense. You don't have to go to 1896. You certainly don't have to go to Colorado in the context of a Florida case. Florida law is the same, and in both the civil and the criminal context. In this case, he's citing here, I guess somebody was being threatened and somebody rushed at him from a crowd and he shot that person, and it turned out it was a deputy sheriff. So mistaken identity case, mistakenly perceived someone as an aggressor. But it was decided that the mistake was a reasonable mistake and therefore it's lawful self-defense, as we've already explained. Let's see. Juries often resolve doubts in favor of the shooter. Well, I would say far more often they don't. Most claims of self-defense are nonsense and are easily defeated at trial. I would say 95% of self-defense claims are nonsense. And if it goes to trial, they're defeated at trial. The ones we hear about in the media are different. But of course, that's cherry picking, right? The media reports on the edge cases, not the common cases. Or at least, local media may report on everything. But it's the high-profile cases, like George Zimmerman, like Kyle Rittenhouse, that are brought to our attention. And often they're brought for purposes that are more political and less based on legal merit. So it doesn't surprise me that the prosecutions of those self-defense cases tend to fail at a higher rate. Juries often resolve doubts in favor of the shooter. It is often perplexing to some of us. Well, if you're talking about cases like Zimmerman and Rittenhouse, the only way it's perplexing that they were acquitted was if you don't understand the law or you don't understand the facts of those cases. For example, there was the notorious case involving the shooting of a Japanese student in Baton Rouge. The 16-year-old Japanese exchange student, Yoshihiro Hattori, was looking for a Halloween party and scared the wife of Rodney Piers when he spoke a strange language and approached the house. Piers shot him in the chest with a .44 Magnum handgun and was later cleared under a Make My Day law as a mistaken defense of his home and self. Well, it wouldn't be a Make My Day law because you wouldn't call Louisiana law that. It would be Louisiana's defense of highly defensible property statute, defense of dwelling statute. And again, it requires a reasonable fear. And of course, we have the case now in New York, right, where the elderly homeowner goes to his front door and there's a young black man on the other side pulling on the handle of the screen door and he shoots him. And the narrative is the young black man was at the wrong house by mistake. He was seeking to pick up his brother who was at some other house in the neighborhood. The legal question there is, did the homeowner, when he opened up his wooden door and he saw this other person attempting to gain entry to his home, which he was doing, or at least there's facts and evidence that's what was happening, perceived him as an unlawful intruder, had a reasonable fear of death or serious bodily injury or home intrusion by that person attempting to gain entry to his home, and shot him on a reasonable basis, lawfully. That will be the defense in that case. So this kind of stuff happens all the time, and reasonableness of the perceptions of what was happening it is almost always a question in self-defense cases. So it's not bizarre or unusual. You may not like the outcome, but of course we solicit jurors to make these findings of facts on the specific facts of individual cases. There was an equally baffling acquittal of a lawyer who shot an elderly farmer armed only with half a broomstick used to guide his bull. Well, I mean, we don't have any facts here. If it's being suggested that half a broomstick could not be used to inflict death or serious bodily injury, that's nonsense. I could certainly kill someone with half a broomstick if that was my intent. Certainly maim them, cause severe brain injury. I mean, it's just a nightstick at that point. He's using it to herd bulls. How soft to the touch do you think that broomstick is? Continuing, this could come down to whether Ford was holding the chainsaw at the time, though Druzolowski's advanced age could factor into whether he reasonably believed that he was being threatened with great bodily harm. It certainly could. In fact, Florida has a statute that aggravates a simple battery into an aggravated battery, a felony battery. So it aggravates a misdemeanor battery to a felony battery based on the age of the victim of the battery. So if under Florida law, I think I might even have the statute. Let me see. Oh, I thought I had it pulled up. Darn it. I know I did. Oh, here it is. All right. So here's the Florida statute. Statute 78408, assault or battery on persons 65 years or age or older. So it's the same physical act. Only the age of the victim has changed. And if we scroll down here, in the case, let's see. In the case of a battery, so whenever a person is charged with committing an assault or aggravated assault or battery or aggravated battery, and you should read this to be misdemeanor, simple assault, or felony, aggravated assault, or misdemeanor battery or felony battery, upon a person 65 years of age or older, regardless of whether he knows the person's age, the offense for which that attacker is charged shall be reclassified. In the case of battery, it goes from misdemeanor battery to felony battery. It automatically jumps from a misdemeanor to a felony, not based on any change in the nature of the attack, but purely on the age of the victim. And if it's a felony, Florida does allow for the use of deadly defensive force to prevent a forcible felony. But this statute will not apply to this case because it applies in the context, this bump from misdemeanor to felony is in the context of a battery. A battery is an actual touching of another person. That's not what Druzolowski is alleging here. He's not alleging that Ford made contact with him. He's alleging that Ford put him in fear of imminent unwanted conduct. And that is assault. That's not battery. And we don't get that bump from misdemeanor to felony based on the age of the victim for assault. It does get bumped from a lesser misdemeanor to a greater misdemeanor, but not to a felony. So this rule here is not going to help Druzolowski in this particular case. Now, that said, does the age of Druzolowski, is it a relevant fact in evaluating the reasonableness of his perception of a deadly force threat? Sure, because the older you get, the more vulnerable you become to suffering serious bodily injury from a particular attack. So a punch that would be a minor, result in minor injury to a healthy 20-year-old could well result in serious bodily injury to someone who's 78 years old, right? You're just more fragile. You could fall and break your hip. I mean, 78-year-olds fall and break their hips all the time. Druzolowski could be on blood thinners. Many elderly people are on blood thinners to help prevent stroke. Well, a punch that's harmless to someone not on blood thinners is fatal to someone who is on blood thinners. So to the extent that Druzolowski's age makes him exceptionally vulnerable to death or serious bodily injury, of course that would play a role. And it doesn't matter that Ford wouldn't be aware of this reality. It only matters what Druzolowski's perception of the degree of threat was to him. Of course, if the threat really is, I'm going to cut your head off with a chainsaw, or I'm going to hit you in the head with a chainsaw, does it really matter what age you are? I would think not. Here is then again, this is muddying the waters, because here Professor Turley writes, here is the relevant provision in the stand your ground law. The stand your ground law. I would argue there is no the stand your ground law in Florida. It's a legal doctrine, but there's no single stand your ground statute. Stand your ground, the understanding that avoidance is taken off the table as a target of attack for the prosecutor, that you're relieved of any otherwise existing legal duty to retreat in otherwise lawful cases of self-defense. It's a legal doctrine that's threaded through essentially all of Florida's self-defense law. There's no one self-defense statute. Most of the self-defense statutes, the ones that set out the elements of self-defense, include within them this relief of the legal duty to retreat. So he cites a paragraph here. It's a shame he doesn't link to the actual statute. This is actually the second paragraph of Florida's self-defense statute. It's the deadly force paragraph. So it's very common for states, when they statutorily define self-defense, they'll have one statute that basically defines non-deadly force self-defense, and a second statute that defines deadly force self-defense, adds additional conditions that have to be met before you can use deadly force in self-defense. That's what Florida does. And this is the second, the deadly force paragraph. I'll just pull up the actual statute here. So it's 776012, use or threatened use of force in defense of persons. And the first paragraph here is when you're justified in using force, not deadly force, force before you get to deadly force. And these are the conditions. And they're essentially the usual conditions of self-defense, except that it's not required that the threat you were facing was a deadly force threat. You can defend yourself against any unlawful threat if you're only using force, but not deadly force. So you're only using non-deadly force. These are the conditions that have to be met in paragraph 1. Paragraph 2 is what Professor Turley cites in this blog post. He doesn't number it or really reference it. But this is what the text of what he's in there. And here you can use deadly force in self-defense to prevent imminent death or great bodily harm. That's proportionality, right? Before you can use deadly defensive force, you have to be facing an imminent threat of death or great bodily harm. Deadly force to deadly force. But look here, let's go back up to the non-deadly force paragraph. A person who uses force in accordance with these rules does not have a duty to retreat. That is stand your ground. But it's not its own statute. It's just threaded into the non-deadly defensive force provisions of self-defense. And we go back to the self-defense statute. And here it says, a person who threatens to use deadly force does not have a duty to retreat if they're not engaged in criminal activity and are in a place where they have a right to be. So there's conditions added for stand your ground in the context of deadly force. But again, stand your ground is not its own standalone statute. It's simply threaded through the other use of force statutes in Florida. Let's look at another one here, home protection. This is the one that creates the legal presumption of a reasonable fear of imminent deadly force harm. Whoops. Let me pull this back up. Change it. Home protection. Here we go. This is Florida's defense of highly defensible property statute. It creates a legal presumption that you had a reasonable fear of deadly force harm when certain conditions are met. I'm not going to make this show all about highly defensible property, but that's what the statute does. And it recognizes, again, that you have no duty to retreat when you're in your dwelling or residence. I would call this the castle doctrine of Florida. It's not its own self-defense. It's not its own standalone statute. It's simply threaded into the defense of dwelling statute. What about defense of personal property? So not highly defensible property, not your home, your business, your vehicle, but just items, personal property of yours. Can you use force to defend your personal property? Yes, but not deadly force. You can use force except deadly force under certain conditions, and it lists out a bunch of conditions. And by the way, if you meet these conditions, you don't have a duty to retreat. So again, this stand your ground concept is not a law. It's a legal doctrine that's threaded through the various use of force laws of Florida. Again, we see it here. It's just threaded through everything. And I think that's about it. But by the way, for those of you who like this level of detail on state-specific detail on use of force law, if you'd like to know this for your state, we do have state-specific courses for all of the 50 states on their use of force law. And right now, actually, we're running a sale. I think it's 60% off. And you can learn more about this at lawofselfdefense.com/state. We make them available as DVDs. We make them available as instant online streamed access. All 50 states are covered as individual state-specific courses. Lawofselfdefense.com/state. Pick your own state. Pick several states if you want. It's all up to you. All right. So that is the entirety of this morning's blog post by Professor Turley that I thought could use some clarification for the law self-defense community and everybody. Only took an hour and a half. How about that? Again, though, as I said very clearly at the beginning, I want to restate it here at the end. I think the world of Professor Turley. He's clearly a legal genius. Again, his bio, folks, is literally, well, not literally, it's figuratively endless. It just goes on and on. The things he's accomplished and been recognized for professionally, legally, academically, just a world-class legal talent. And frankly, it's when it comes from a world-class legal talent, this kind of what I see as muddying of the proper understanding of these legal doctrines of use of force law, that I think it's most important to try to bring back clarity. If just a journalist does this, it can be discounted. But here we have a world-class legal expert. So that's why I thought it was all the more important. But none of this is intended as a personal or professional diss against Professor Turley. I think the world of him. I've read a lot of his work, and it's almost invariably awesome. So certainly don't discount his expertise simply because I thought this particular blog post lacked a certain degree of clarity. Again, no offense, Professor Turley. I doubt you'll ever see this, but should you see it, no professional or personal offense intended. You do great work, and keep it up. The world needs it. All right. So with that out of the way, I think I'll take a look now at the chat. If anybody in the chat is still alive after an hour and a half. And at the bottom of the screen there, folks, I put the reminder for our upcoming Law of Self-Defense advanced class taking place, our full day advanced class taking place on Saturday, October 7th. Go to lawselfdefense.com/advanced. I have like a 20-minute video there that explains everything we cover in the course. We have various options for registering as low as $149, folks, for 8 hours of expert use of force law instruction. The last one we're doing for this year, the next one will be at least 6 months. All these red bullet points on the screen are the more than 100 very specific use of force law questions we answer over the course of the day, and we cover all the Q&A, which sometimes seems pretty endless. So learn more about all this. And if you can't make the date, Saturday, October 7th, then I would encourage you to register anyway and just access the playback version. We'll make that available to all the registered students afterwards as well. All right. Let me take a look at the chat. Let's see. Yeah, of course, we don't know. Someone mentions electric chainsaws. We don't know the nature of this chainsaw. If it was gas, if it was electric, of course, it can start up in an instant, right? There's no pulling of a start cord, ripcord. Jeffrey asks, if you're charged, here, let me pull this over so I'm not looking sideways at the camera like this. Jeffrey, Law Self-Defense. By the way, folks, we only take questions and comments from our Law Self-Defense members. So if you're not a Law Self-Defense member, I won't even see. If you're putting comments and stuff in YouTube, I won't even see it. So I would encourage you not to do that. I would encourage you to become a Law Self-Defense member, which is easy to do. It's only 99 cents. So you can become a Law Self-Defense member for 2 weeks, 2-week trial membership, 99 cents, unlimited access to all our members-only content. And after the 2 weeks, it's only about 30 cents a day. It's less than $10 a month to be a Law Self-Defense member. Watch the show on your member stream. We have lots of members-only content that's only on the member stream. And when we do open access content like we're doing today, we only look at comments and questions from the members in the member chat. Become a member right now. Open up another tab in your browser, lawselfdefense.com/trial. You'll get instant email on how to access today's live stream and all our other members-only content. So, Law Self-Defense member Jeffrey asks, if you're charged with reckless manslaughter instead of intentional murder, do you tend to lose any legal presumptions of self-defense? If so, can you still argue that I did not act recklessly, but I intended to do it to regain those presumptions? Well, you're always arguing that you didn't act recklessly. Always. Because if you acted recklessly, that you're done. So you always have to be combating that. Normally, you don't have to bother unless you're charged with a crime of recklessness. But if you are charged with a crime of recklessness, by default, you're arguing that your conduct was not reckless, or you're just guilty of reckless manslaughter. And if you're arguing it was not reckless, it was intentional, then sure, you get the benefit of those legal presumptions if you qualify. Let's see. Bup. Kyle asks, can both Castle Doctrine and Make My Day be cited, or does Make My Day encompass supersede Castle Doctrine? Well, again, Make My Day is only Colorado. But in Colorado, there could be two possible. Castle Doctrine and Make My Day remove two different targets of attack for the prosecutor, right? Castle Doctrine removes as a target of attack the element of avoidance. The prosecutor cannot argue that you violated the element of avoidance by failing to retreat. You don't have a legal duty to retreat in your home under the Castle Doctrine. Make My Day removes the element of proportionality as a target of attack for the prosecutor. So each of these things does two different jobs. So yeah, of course, you can argue both if you need to. If either of those elements, avoidance or proportionality, were being attacked by the prosecutor and Castle Doctrine or Make My Day applied, you would counter those attacks by saying, no, those targets are not available to you, Mr. Prosecutor. Let's see. Philip says, ignorance of the law is no excuse, but the law is constantly argued in courts all the time. Not to mention this session on what Turley discusses, how can a layperson not be ignorant of the law? You know, it's funny you asked that. This would be a good way to not be ignorant of the law. Take our law self-defense advanced class, at least the law of use of force, defense of yourself, defense of others, defense of property. The truth is, use of force law is pretty straightforward. The black letter of the law is not complicated. There's not 500 elements on this cheat sheet. There's only 5. And often, not all 5 apply. 39 states are stand your ground states. They don't apply the element of avoidance to an otherwise lawful case of self-defense. So there's only 4 elements of self-defense in 39 states. So it's not rocket science. And the trouble is that people only think they know where the legal boundaries are. And they step over those legal boundaries blindly and end up vulnerable to conviction when that didn't have to be the case. So you're much less likely to make errors, mistakes of law, if you learned what the actual law is, which is what we teach at this class on Saturday, October 7th at lawofselfdefense.com/advanced. Register today. Okay, back. I lost my little, here we go. Lou says, I hope Professor Turley is made aware of Andrew's excellent critique of his flawed blog and perhaps would do an interview with Andrew. I would love that. I'd be honored to have Professor Turley on. This has happened before, right? There's been other law professors who's either a law review article or whatever I critiqued. And every once in a while, they do reach out. They give me a call or send me an email. And usually it works out pretty well. We end up having lunch and I have him on as a guest on the show. And it's great. But I never presume that's going to be the case. Professor Turley's on a different class level than this. I'm just a small town lawyer in Colorado, folks. Let's see. Listen, Jeffrey says, it seems Turley is trying to exercise his intelligence by conflating other states' laws to prove his point. Needs to either focus on Florida law or better disclose how those other state laws do not apply. Folks, my sense here is that Professor Turley writes blog posts on a regular basis, maybe several times a week for his blog. He's got a limited amount of time to write each one. He's not going to acquire my level of expertise in use of force law to write a simple one-off blog post. I don't think that would be a reasonable expectation. So I think this is kind of, when you write on a wide variety of topics, from time to time, you're going to be writing on a topic where you have, kind of a general understanding maybe of what's going on, but not a really in-depth understanding. And I just think that's what's reflected here. I just think this case is in the news. Look, he probably does what I do. He wakes up in the morning. What can I talk about today? What can I write about today? Oh, this thing's in the news. Let me share what I know about this area of the law. It just happens that what he knows about this particular area of the law, use of force law, lacks clarity. Okay. And I think, oh, no, there's more. There's more. I thought I was done. Miles asks, if I tell an invited guest to leave and I use surprise non-lethal force, if he then escalates and is capable of disproportionate non-lethal force, would I have lost my innocence to use lethal force in the new? So I'm not sure what you're asking, but let me try to paraphrase it in a way that I can answer. So you have an invited guest in your home. By the way, if the guest is invited, often you do not have any legal presumptions of reasonable fear with respect to that guest, because they did not gain entry unlawfully. They gained entry lawfully. You invited them in. So that's one thing to think about. But they're an invited guest and you don't want them there anymore. They got drunk, they're causing trouble, whatever the case may be. So you tell them to leave. If you give them a reasonable opportunity to leave and they haven't left, now they're committing a simple trespass. Can you use non-deadly force to remove a simple trespasser? Sure, you can. You grab them by the arm. They resist. Can you use an escalating degree of non-deadly force proportional to what's required to remove them? Yes, you can increase your your buddy can also grab his other arm. Somebody can grab his legs. You're increasing the amount of non-deadly force you're using in order to carry out your privilege to remove a simple trespasser from your property. That's all good. The problem happens is, what if they respond to your non-deadly force with a deadly force response? Have you lost innocence because you were the initiator of the non-deadly force? And the answer is no. Because the unlawful aggressor is the person who initiates unlawful force, not lawful force. And if you're using lawful force, non-deadly force to remove a trespasser is lawful. Your force is lawful. So you're not an unlawful aggressor in that confrontation. They become the unlawful deadly force aggressor when they respond with deadly defensive force. So, and then you would have a privilege to defend yourself with when they escalate to deadly force, aggressive force. And then you would have a privilege to use deadly defensive force to defend yourself against their unlawful deadly force attack. But can those fact scenarios get ambiguous? Do people disagree about what happened? Is that narrative going to be believed by the jury, or can the prosecutor convince them that something else happened? Because remember, nobody who's judging your conduct after the fact was there. They have no personal knowledge of what happened. Might the person you're trying to remove, might he have friends or family at the same party who were willing to lie about what led up to you shooting him? So that's the risk. It's not the black letter of the use of force law. It's the facts that get complicated and ambiguous. Let's see. Boom, boom, boom. A number of people noting that they're older, like all of us. We're all older folks. And you're less resilient, less easy to run away, less easy to defend yourself without resorting to a weapon, without suffering serious injury. Sure, that's all true. Prosecutors hate that, of course. They'll routinely bring in evidence about the last time you rode a bicycle. He's not really that old and that decrepit, like he's trying to suggest. He's faking it. He's coming into court with a cane to make you think that he was exceptionally vulnerable to. But we have testimony just a few years ago. He was on a bicycle, not that unhealthy. You see that all the time. We saw that in the Florida movie theater shooting. Let's see. Oh, the times for the advanced class starts 9 a.m. Mountain Time. So is that right? Yeah. So 11 a.m. Eastern Time. Adjust for your time zone. Again, if you can't make it, or you can only make it for part of the live class, I would still encourage you to register, because we'll make the playback of the class available to you as well. Let's see. And we do give a 10-minute break every hour during the course of the course. Yes. Let's see. A lot of talks about outrunning the bear. Yeah, there was a cane. I took a flight last weekend. There was a cane on the flight. It's so they go through all this theater about. I've seen knitting needles on flights. It's just everything's a weapon, folks. If properly approached. Canes would be particularly effective. It's yeah, and folks, I often fly business class and they give me metal cutlery on the plane. It's amazing. They wouldn't let me bring a little pocket knife through security, of course. I wouldn't make the attempt, but you get on the plane, they give you silverware. Metal silverware. It's crazy. All right. Well, I think that's all we have for today, folks. So I'm going to go ahead and wrap things up. Not sure if I'm doing a show tomorrow or not. I may have a conflicting commitment tomorrow, but this is the fourth show this week. This one's almost 2 hours long, as many of them are. So I hope you feel you're getting your money's worth. And with that, I'll remind all of you, if you carry a gun so you're hard to kill, carry a knife so you're hard to kill, carry pepper spray so you're hard to kill, study jujitsu so you're hard to kill. I was doing arm bars just yesterday. I got to get better at those. A little sloppy. But if you're doing any or all of those things, I do all those things, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain attorney Andrew Branca for Law Self-Defense. Stay safe.